My lady, it is true that in your earlier answer, you indicated that a CI perhaps may suffice. In fact, that was your third suggestion by way of solution. You had earlier talked about when the matter comes before the court or a proposal being made to the Constitutional Review Committee, and now you've added that perhaps also a CI may suffice to help. I have asked you about the possibility of double jeopardy. It is not always likely that constitutional bodies may see it in that light, that the person has already been punished and that they should be guided. It is a reason I wanted for emphasis to ask you that do you think to bring a finality to this matter, a CI comprehensive enough to guide becomes the appropriate approach in this respect? That is all I wanted you to emphasize. That's all.
Honorable Member, this question has been asked and answered severally. So with all due respect, proceed to ask another question.
My lady, do you think that unilateral imposition of fines on defaulting appointees affect public trust in SHRAJ and the constitutional process for addressing misconduct in such manner?
I do not think so, Honorable Chair.
Reasons? Reasons, my lady.
I do not envisage a situation where an administrative action would lead to loss of trust or confidence in a constitutional body. I do not envisage it. Thank you.
But my lady, you would agree with me that this democratic enterprise or this journey of democracy is perception driven, and at all points where the public perception tilts in a certain manner, it requires decision makers to make amends. You agree with me?
Can I have the question repeated, Honorable Chair?
As a follow-up to your answer, my point is that democracy is driven by perception, public opinion. So don't you think that where the public view on a particular matter is negative, it calls for revisit or rethink in decisions?
Thank you, Honorable Chair. It depends on the basis upon which the decision was taken. That is what would determine whether or not the matter can be revisited. The basis and whether or not there will be another opportunity for that matter to be revisited. Thank you, Chair.
Thank you. My lady, we are done with the SHRAJ issues. I want to pick your thoughts on the EC, and I'm focusing on the public criticism surrounding the creation of new constituencies, particularly the apparent alignment between new district created by the executive and the subsequent constituency demarcations by the Electoral Commission. I would anchor the questions on Article 47, 45, 46, and 47 of the Constitution. So, first will be to know your views on separation of powers and the constitutional independence. So, question: how should the independence of the Electoral Commission under Article 45 and 46 be protected or interpreted in the face of public perception that it simply mirrors executive decisions on district creation when establishing new constituencies?
Thank you, Honorable Chair. I believe that the independence of the Electoral Commission is guaranteed by law, so I do not see a situation where their independence will be interfered with.
Very well. Now, given the fact that creation of districts is an executive function and the demarcation of constituencies is constitutionally vested in the Electoral Commission, what, in your view, would you consider as the legal and institutional risk when these processes appear tightly aligned in practice? I'm sure you remember the recent situation in the Oti region. Is it Salah? The South. My friend Franklin Kujo. My friend Franklin Kujo has been very passionate about this. Of course, that's where he comes from, and all. With that in mind, if you could express a view on it.
Honorable Chair, I would pray to be excused from answering this question. The reason being that there's a pending matter in the Koforidua Court of Appeal in respect of these matters.
Yes. My lady, specifically, just guide us. The sub judice rule you are triggering, in my view, must be put in context since it is not absolute. So please guide us. Within the context of my question, what aspects of the question juxtaposed against the issues before the Court of Appeal do you think would amount to sub judice? Should you answer? I just want us to clarify that for us.
Thank you, Honorable Chair. Now, the legality of creation of constituencies or districts is necessarily a matter that is an issue in the matter before the court. Thank you.
My lady, I disagree with you, but I won't pursue. Now, may I know your thoughts on the safeguards that should exist to ensure that the Electoral Commission's power to create new constituencies is not intentionally or inadvertently be to advance partisan interests or perhaps entrenched political power. The thrust of my question has to do with how we can safeguard you as a judge. What proposal, what views can you express as part of enhancing and enriching democracy? What view can you express as part of the safeguards?
Thank you, Honorable Chair. I believe that the Electoral Commission is independent, and I do not see any particular proposal that I can make that would add anything to their independence. Thank you.
My lady, in situations where clearly you see that the constituency being created is following a certain pattern just because there is a creation of a new district. In instances like that, do you think that it may require the court's intervention to place a limitation?
Thank you, Honorable Chair. Honorable Chair, I would pray to be excused from answering this question as well. And I'm being very careful because the issue of SAL, creation of new districts, new constituencies, is a matter that is yet to be determined in the Koforidua Court of Appeal. So I'm very careful not to go into matters that are yet to be determined by the court. Thank you, Honorable Chair.
My lady, in the light of recurring criticism that the creation of constituencies follow executive interest too closely and emphasis too closely, do you think that our country's legal framework on districting and constituency creation needs any reform at all?
Thank you, Honorable Chair. I do not have that impression that the creation of districts follow executive interests. I am yet to be, to come to that realization. So I'm unable to make any suggestion or comments on this. Thank you, Honorable Chair.
Now, you are aware that our district assembly or a local governance concept is constitutionally non-partisan. Do you think that in view of other jurisdictions like the United Kingdom, the United States, where local governance is part of the partisan democratic system, Ghana should pursue a reform?
I do not believe so, Honorable Chair.
What is your basis for saying that we should remain with what we have and not reform to make them part of the partisan process?
I believe that the non-partisanship of the district assemblies is better for cohesion and development at that level. That is my position.
But my lady, it is also a notorious fact that the political parties sponsor their activists to pursue their interests at the local governor level in district assemblies. With that view generally known out there in mind, would you still maintain that there should be no reforms to reflect this?
Yes, Honorable Chair, I'll still maintain so.
Very well, my lady. My lady, I would now want to focus on the contrast between qualification required for member of parliament and those required for judges, particularly in the light of the public criticism that MPs are not held to any formal education or professional standard, while judges must meet rigorous legal qualifications. Now, the IEA survey shows, a recent IEA survey shows that 67% of Ghanaians believe MPs should have at least a university degree. How do you reconcile this strong public sentiment with a constitution silence on educational qualification for MPs, especially when judges face strict legal and professional requirements in their selection?
Thank you very much, Honorable Chair. I believe that the two categories of functions are different. A judge is a professional and ought to be able to apply the law, because you are primarily a judge because you are a lawyer and you have legal knowledge. But there's no such requirement for members of parliament. And I do not think that there is any reason to insist that every member of parliament must have a university degree. because primarily they are representatives of their people. And if their people think that they are competent enough to come to the House and represent them, I think that should be it. Thank you.
Well, what role, my lady, if any, should our courts have, whether direct or imperative, in responding to the public concerns about the standard of political governance in our country?
If the question may be clarified.
What role, if any, should the courts play as part of the governance of the country to, as it were, enrich the political governance? You are here in this country, and I'm sure you follow the public discourse. Sometimes people criticize, people say, oh, governance, the standards are low, the standard is this, the expectation is quite mixed. As a judge who is going to sit in a court that determines public policy, do you think that the courts have, the Supreme Court, let me be very specific, the Supreme Court has any role at all to play in the light of this to enhance the political governance of our country?
Thank you, Honorable Chair. The courts have been given the role of adjudication, and I believe that if there are matters that come before the Supreme Court, which also hinge on political governance, and the court has to determine them, the court will determine them accordingly. And if that in any way would enhance governance, I believe that it will be in a good direction.
My lady, are you a registered voter?
I'm a registered voter, yes.
My lady, which constituency did you register?
I registered in the La constituency. I don't know whether it's called La, but it's at the La area, yes.
La Dadikotopon.
I don't know if
that's the full name of the constituency,
yes,
La
yes.
Dadikotopon.
Yes.
Okay. Which area, which polling station or center specifically? The area you were trying to describe, the area where you registered. Which area?
It's at La.
La proper. I know, I lived in La. That's why I'm asking. I know La very well. So which area? Is it the trade fair area, La Wireless, or where the South La Nyaniba Estate area?
No. It's not. It's within La proper. Yes, it's within La proper.
Very well.
Honourable members, I'm inclined to overrule this particular question. What we should do in vetting the judges are governed by law. Which political polling station they cast their vote, I don't think on grounds of relevance is not required.
Lord, grant me patience. Lord, grant me patience.